Yes, you can proceed. Sorry about all that.
Okay. All right. Let's from the beginning. Good morning, everyone. The May 25th, 2021 meeting of the Charlotte Zoning Board of Adjustment is now in session. I am Patrick Welch, the chairman. Also sitting on today's board is Ms. Deborah Dryden, Ms. Krista Long, Mr. Douglas Wilson, Mr. John Floyd, Mr. Raghu Kotha, and Marshall Williamson. Also present are Shad Spencer, zoning administrator, Lisa McCarthy, planning project manager, Terry Hagler Gray, senior assistant city attorney, Jill Sanchez, Jill Sanchez Myers, senior city attorney, Max Oliver, clerk of the board, and Atkins court reporting verbatim reporter. I would like to start by acknowledging that we are conducting this meeting using a remote electronic platform. This is the 12th remote meeting of the Charlotte Zoning Board of Adjustment, and I would like to ask for your patience today as we proceed. There may be slight delays as we transition between speakers, participants, and presentations. The Zoning Board of Adjustment is a quasi-judicial board that is governed by the North Carolina General Statute and the Charlotte Zoning Ordinance. We conduct every evidentiary hearing on a request for variance and appeals, among other requests. Before we begin to hear the cases on today's agenda, I would like to provide some important information on the steps that we've taken to ensure that each party's due process rights are protected as we proceed in this remote platform. First, today's meeting will be conducted in accordance with special legislation passed by the North Carolina General Assembly in Session Law 2021-3 that allow for remote meetings and quasi-judicial hearings during the declaration of emergencies. Second, excuse me. Second, each applicant was notified before being placed on today's agenda that the meeting would be conducted using a remote electronic platform. Every applicant on today's agenda has provided a signed consent to the board prior to conducting the evidentiary hearing on their request using this remote platform. Third, notice of this meeting was provided to the applicant and the public in a number of ways. Notice of today's hearing was mailed to the property owners within 300 feet of each subject property and notified the property owners of the remote electronic platform, and the letters also stated to contact the city immediately if there was any objection to the case being heard on today's agenda. Notice was also provided by placing signs on each property and by publishing notice on the city's website. The notices for today's meeting contain information about means by which the public can access today's proceedings. Finally, any individual wishing to participate in today's evidentiary hearing were required to sign up prior, prior to today's proceedings. This information was also included on the board's website. Applicants for a variance for the regulations on the zoning ordinance. The order of the recommendation agenda will be as follows. The zoning administrator or zoning staff member will identify the case and recommend approval of the variance with any recommended condition based on specific reasons. The zoning, excuse me, the zoning administrator or zoning staff member will identify that the chairperson will ask for if anyone wants to speak in opposition. If there is such a person, then the case will be moved to the regular agenda and will be heard on it on a later date. The chairperson will ask if the board has questions, staff, or if there is any reason the board wishes to move the case to the regular agenda. The chairperson calls for a motion and a second to approve the variance. The chairperson will hold a roll call vote. The order of the agenda will be as follows. All parties, all parties who plan to give testimony pro or con will be sworn in. A zoning staff member will explain why a permit was denied or why a variance is requested. The board may question the staff member, and then the applicant may question the staff member. The applicant presents their testimony for their case. The board may question the applicant, and the staff member may question the applicant. The applicant may present sworn witnesses. They will be subject to questioning. Other parties wishing to speak pro or con will be given reasonable time to present sworn testimony. The staff and then the applicant will be given the opportunity for rebuttal. The chairperson calls for a motion and a second to approve the variance. The chairperson will hold a roll call vote. After hearing each case, the board will review each case and render a decision. This is usually done in closed deliberations after hearing each regular agenda case. However, the board may elect to take up to 30 days to render a decision. You may remain present during the deliberations, or you may call the zoning staff after the session to receive the decision of the board. All exhibits must remain with the board. Exhibits were required to be provided to the clerk no later than 12 p.m. on Monday, May 24th, in order to be considered at this hearing. If your case is not appealed to Superior Court after 30 days, you may pick them up or they will be destroyed. If you feel, excuse me, one second, I lost my way. If you feel there's a conflict on today's, if you feel there's a conflict of interest of any member of the board or an association that will prejudice your case, please let it be known at the start of your case. The board is acting in a quasi-judicial capacity for the purpose of this hearing and can only accept sworn testimony. While the board will not specifically exclude hearsay evidence, it is only giving limited weight. The North Carolina State Bar had issued an advisory opinion that is the unauthorized practice of law for any individual who is not an active member of the bar to appear for another or otherwise assist or represent another at a quasi-judicial hearing on the zoning and land use matters. All applicants should have been provided with a copy of the advisory opinion as part of the application package. If you are a property owner or a non-lawyer here on behalf of a property owner and have not received a copy of that opinion, please use the WebEx platform function to message the clerk. The documents will be provided to you. If, as a result of the advisory opinion, the applicant would like to request a continuance of his or her case, the board will consider such request at the start of that case. Appeals from this board is to the Mecklenburg County Superior Court. You have 30 days from the date of this board written decision in which to appeal in accordance with North Carolina General Statute 160A-33E. In order to receive a written copy of the decision, an aggrieved party must file a written request for a copy of the board decision by filling out the form, which must be filed with the board clerk or chairperson at the time of the hearing of the case. Please remember to mute your microphones when you do not intend to speak. You will hear 6 cases today, 4 recommendation agenda items and 2 regular agenda items. The first case, 2021-020, 11600 Old Surrey Lane, presented by Lisa McCarthy. Present the case.
All right, our first case is a residential setback variance. The applicant is requesting a 25-foot variance from the 55-foot required setback along Williams Pond Lane to construct a pool. And in the March ZBA meeting, the ZBA continued the public hearing so that the applicant could provide a sealed survey showing the proposed measurement of the pool encroachment. Members of the ZBA were emailed the recording of the case from the March meeting for the purposes of the continued hearing. The applicant has revised the variance request since that March meeting because the applicants previously requested a 38-foot variance into the 55-foot setback. So if you have heard the case or were at the March meeting, you would be available to sit in on this case as a ZBA member. And I'll give you a few minutes to look over the revised findings, and if the chair will just let me know when you would like me to proceed with the presentation.
Okay, thank you.
And I would ask who's sitting on the case as well.
Has the revised findings been sent out?
Yes, they were sent to your email this morning.
So who we have that was who be sitting on this case?
This is Deborah Dryden. I was on that case in March, so I'll be sitting.
Same here. This is Douglas Wilson. I was sitting on that case on March 30th.
Okay.
As was Crystal Long.
Okay, so we have Ms. Dryden, Mr. Coulter, Ms. Long. Has Mr. Floyd joined us?
Mr. Chairman, this is Marshall Williamson. I was not on the call in March and have only recently been sworn in. So you guys tell me if I'm available to sit on this or not.
Unfortunately, if you was not on that March call, you were unable to sit on this case. Am I correct in saying that?
The video of the case was sent out as well. So if you've seen the video, you should be all right to sit on the case.
So I have Ms. Deborah Dryden, Ms. Crystal Long, Mr. Douglas Williams, Mr. Raghu Coulter, and myself will be sitting on this case.
Okay, if you'd like to review those findings and just let me know when you would like me to proceed. Thank you.
Okay. Lisa, you can proceed.
Exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map of the property. The property is zoned R3 single family. Exhibit number 3 is an aerial map of the property. And exhibit number 4 is a close-up aerial map of the property. Exhibit number 5 is background of the property. The property was subdivided in 1986 and shows a 55-foot setback from Providence Road West, which is now called Williams Pond Lane. Since the setback and rear yard both abut streets, the rear yard is the same as the required setback in the district. Although the setback for the R3 zoning district is 30 feet, the 55-foot setback shown on the approved plat supersedes the required zoning setback. Exhibit number 6 is the variance request. The applicant is asking for a 25-foot variance from the 55-foot setback along Williams Pond Lane to construct the pool. The existing pool location shown is where the pool was placed by the pool contractor, which was not permitted. Staff supports the requested variance location shown in red on the survey. And that would leave a 30-foot setback from Williams Pond Lane. Exhibit number 7 is a consideration that the applicant has reduced the variance request. As previously mentioned, the applicant has reduced the variance request from 38 to 25 feet. So the current request would result in a 30-foot setback, which is consistent with the required 30-foot setback in the R3 zoning district. So you can see on the left the original request as opposed to on the right the current request. Slide 8 is further considerations. Staff supports the requested variance. The current variance request is consistent with the intent of the ordinance. because of the required 30-foot setback of the R3 zoning district. The hardship is not a result of actions taken by the applicant who state they were unaware of the 55-foot setback requirement until they tried to install the pool. The hardship results from conditions peculiar to the property and the increased setback requirement imposed by the plat because street improvements recommended in the I-485 interchange analysis plan were made to Williams Pond Lane in 1999. The existing nonconforming home on the property encroaches 14.2 feet into the 55-foot setback because at the time of construction, there was not a requirement that setbacks shown on the plat take precedent over the required setback for the district. Also, the setback decreases the allowed building footprint for an accessory structure in the functional rear yard of the property, which is typically permitted up to 3 feet from the side and rear yard. Granting the variance will not change the character of the area and couldn't be easily detected because of screening by a fence, vegetation, and retaining wall, and a 4-foot grade change along Williams Pond Lane. Granting the variance will not impact public safety. Exhibit number 9 is a photo of the front of the property. And that's the end of my presentation. If you have any questions for me.
Does anyone have any questions of the staff? Is there any questions? I ask for a motion on this case.
Dryden, I make a motion to approve this variance. The homeowner has done everything we requested. They have completed the survey and they have reduced the amount of the variance. So I vote to approve this.
And
I
this
have a
is
motion.
Wilson, I second.
I have a motion to approve from Ms. Dryden and a second from Mr. Wilson. All right, Senator roll call vote. Dryden,
Dryden, yes.
Wilson,
Wilson, yes.
Ms. Long,
Long, yes.
Coulter,
Raghu, yes.
Ragu, yes, and a yes for myself. So the motion has been passed. Go to the
A motion
fact
to
and findings.
approve. Yeah, I make a motion to approve the finding of facts and positions of law as written.
I have a motion to approve the findings of facts from Ms. Dryden. Do I have a second?
I will second it. Raghu Kota seconds.
Okay, Mr. Ragu, second. Senator, roll call vote. Ms. Dryden,
Dryden, yes.
Ragu,
Raghu, yes.
Mr. Wilson,
Wilson, yes.
Mrs. Flo, Mrs. Long,
Long, yes.
and a yes for myself. So the facts and findings have been approved as written. Move on to our next case.
All right, our next case is a residential street side yard variance request. The applicant is requesting a 3.1-foot variance from the required 15-foot street side yard for an existing addition to the principal structure. And I'll give you a few minutes to look over your findings. If you want to just let me know when you've had time.
Max, were those findings sent out?
Yes, they were all included in the same PDF file.
Thank you for having me. Kanisha, you can proceed.
All right, exhibit number 1 is a vicinity map of the subject property. Exhibit number 2 is the zoning map. It's zoned R3 single family. Exhibit number 3 is an aerial map of the property. And exhibit number 4 is a close-up aerial map of the property. The property is located on the corner of Wintercrest Lane and Audrell Drive, with the front of the lot oriented towards Wintercrest Lane and the side of the lot along Arundel Drive. There's a 15-foot required street side along the side yard, which is 1/2 of the required 30-foot setback for the R3 zoning district. Exhibit number 5 is background. In 2009, a permit was issued for an addition to the home along the street side yard. The 15-foot minimum street side yard was noted on the building permit. The applicants are now selling the property, and a survey commissioned by the buyer shows that there's a 3.1-foot encroachment of the addition into the 15-foot street side yard. Exhibit number 6 is the variance request. The applicant is requesting a 3.1-foot variance into the 15-foot street side yard for compliance of the 2009 addition. Exhibit number 7 is considerations. Staff supports the requested variance. The hardship does not result from actions taken by the applicant because the applicants obtained a building permit for the addition and stated that they were unaware of the encroachment when the addition was built in 2009. Staff believes that the street side yard may have mistakenly been measured from the curb line instead of the street right-of-way as required. This could have caused the impression that the requirement was met, since measuring to the curb gives a greater distance, and you can see this in the graphic on the right side of the screen. Unnecessary hardships would result from the strict application of the ordinance, which would cause a portion of the 2009 addition to be demolished. The hardship results from conditions peculiar to the property because the lot is on a corner and there is a greater side yard dimension for the street side yard than the typical side yard. There is a 50-foot setback along Wintercrest Lane for the recorded plat, which is 20-foot greater than the required 30-foot setback for R3, and that also reduces the allowed building footprint for the property. Granting the variance will not adversely affect adjacent or contiguous properties because the addition has been there for 12 years and it's not easy to detect. The encroachment exceeds the 2-foot administrative deviation provision in the ordinance by only 1.1 foot. So if it was 1.1 foot less, it would be eligible to get that administrative deviation, which would not have to go before the board. Exhibit number 8 is applicant submitted photos. Granting the variance will not alter the essential character of the neighborhood. The applicant has submitted photographs of the home addition, and they appear in character with other homes in the area. Exhibit number 9 is a photo of the front of the property. And that's the end of my presentation. If you have any questions for me.
Okay, I would like to appoint sitting on this case will be Ms. Dryden, Ms. Long, Mr. Wilson, and Mr. Ragu. Are there any questions from staff members on this case? Hearing no questions, then I'll ask for a motion on this case.
I move that we approve the variance. This is Wilson.
Have a motion to approve the variance from Mr. Wilson.
I will
Dryden,
second.
second.
I have a second from Mr. Ragu. Senator roll call vote, Mr. Wilson,
Wilson, yes.
Mr. Ragu,
Raghu, yes.
Mrs. Dryden,
Dryden, yes.
and Mrs. Long.
Long, yes.
And it'll be a yes for myself. The motion has passed, the variance has passed. Going over the facts and findings.
This is Dryden. I vote to approve the finding of facts and conditions of law as written.
I have a motion to approve the finding of fact and condition of law from Mr. Dryden. Do I have a second?
Long second.
I have a second from Ms. Long. Roll call vote, Mr. Dryden,
Dryden, yes.
Mrs. Long, Mrs. Long,
Yes.
Mr. Wilson,
Wilson, yes.
Mr. Ragu,
Raghu, yes.
and a yes for myself. The facts and findings and condition of the law has been approved. As written. Moving on to the next case, case 036.
This is a residential. I'm sorry.
sorry.
Go ahead.
Also sitting on this case will be Mrs. Dryden, Mrs. Long, Mr. Wilson, Mr. Ragu, and myself.
The next case is a residential accessory structure variance. The applicant is requesting a variance to permit an accessory structure in the established setback on the property. And I'll give you a minute to look at your findings if you would just let me know when you're done.
Felicia, you can proceed.
Exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map of the property. The property is zoned R3 single family. Exhibit number 3 is an aerial map of the property. Exhibit number 4 is a close-up aerial map of the property. Since this is a newly constructed home, it's not shown on the aerial photo yet. The property has access from a shared driveway off of Close Burn Road, which is in the rear yard of the property, and the plat shows the existing home footprint. The home is oriented towards the shared drive, and the rear of the home is oriented towards the front setback along Glenkirk Road. The orientation is due to the location of a creek that forms the property line and right-of-way along Glenkirk Road. So basically, the home is located kind of backwards of how the rear and the setbacks are. Exhibit number 5 is background. The property was subdivided in 2019, and there is a 76-foot setback from Glenkirk Road in the functional rear yard of the property. The bottom right photo shows the home's shared drive from Closeburn Road and the limited rear yard area. So if you look at that, you can see that there's hardly any rear yard left once you take that driveway and parking area. Exhibit number 6 is the variance request. The applicant is requesting a variance to allow a swimming pool in the established setback between the home and Glenkirk Road right-of-way. Staff supports the requested variance. The proposed location is outside of the 76-foot required setback and outside of the stream buffer area. Exhibit number 7 is considerations of the request. The hardship was not caused by the applicant and is caused by unique property conditions. The shared driveway and parking in the rear yard and the increased 76-foot setback lessen the rear yard area to place the pool. The creek along the Glenkirk property line and right-of-way line prohibits vehicle access. There's a 50-foot stream buffer along the first 50 feet of the property, and that has significant vegetation. Also, there's not adequate building area along the right or left side of the property for the proposed pool. Granting the variance will not alter the essential character of the neighborhood because the pool will not be easy to detect due to the significant vegetation and retaining wall that would screen the structure from view. Granting the variance would not impact public safety. Exhibit number 8 is a photo looking from Closeburn Road onto the shared drive, and the home with the star on it is the property in question. And that's the end of my presentation. If you have any questions for me.
So one question I had was, you said there are no safety issues, right? Are there any neighboring safety issues for when they add the pool?
There should not be any safety issues when they add the pool. The pool will be located out of the swim buffer area from the creek in the rear yard.
Got it. Thank you.
Are there any other questions for staff? Max, anyone oppose this variance?
And there's no one to signed up to speak about this case.
There's no questions. No one signed up to speak. Go ahead, Mr.
This is Long. I approve. I make a motion to approve the variance request.
Okay, I have an approval from Mrs. Long on the variance request. Do I have a second?
This is Raghu. I second this.
And I have a second from Mr. Ragu. Roll call vote. Mrs. Long,
Long, yes.
Mr. Ragu,
Raghu, yes.
Mrs. Dryden,
Dryden, yes.
Mr. Wilson,
Wilson, yes.
and a yes for myself. The variance is as approved. Going over the facts and findings, facts and findings of law. Ask for a motion.
This is Dryden. I make a motion to approve the finding of facts and conditions of law.
Have
Long
motion
second.
to approve. Have a second from Ms. Long. Roll call vote. Ms. Dryden,
Dryden, yes.
Mrs. Long,
Long, yes.
Mr. Wilson,
Wilson, yes.
Mr. Ragu,
Raghu, yes.
and a yes for myself. And the findings of facts and conditions of law are approved. Moving on to our next case, 2021-042. Sitting on this case, Mrs. Dryden, Mrs. Long, Mr. Wilson, and Mr. Wilson. You're still on the line?
I'm here.
I'm sitting on this case as well.
All right, the next case is a transitional setback variance request. The applicant is requesting a 10-foot variance from the required 40-foot transitional setback to construct a deck on the front of a structure. And I'll give you a few minutes to look over your findings if you'll just let me know when you're done.
Commissioner Nixon, can proceed.
Exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map of the property. The property is zoned institutional conditional district, and it was subject of a recent rezoning in 2019. Exhibit number 3 is an aerial map of the property. And exhibit number 4 is a close-up aerial map of the property. Exhibit number 5 is background. The property has an existing structure built in 1973 and is in use as a daycare. A conditional rezoning to institutional CD was approved for the site in 2019. The approved plan doesn't show the transitional setback for the property, and I'll explain a little more what the transitional setback is on the next slide. Slide 6 is the variance request. The property is located along West Sugar Creek Road, which has an existing right-of-way of 25 feet measured from the street center line. It's a major arterial thoroughfare, and there's a required proposed right-of-way of 50 feet from the center line. The institutional district requires a 40-foot setback, and when you have that proposed right-of-way requirement, you measure that setback from the proposed right-of-way. The area between the setback measured from the existing right-of-way and the proposed right-of-way is the transitional setback area, and that's what you see highlighted in yellow there on your screen. The applicant is requesting a variance of 10 foot from the 40-foot transitional setback to construct the deck. Exhibit number 7 is considerations. Staff supports the requested variance. The hardship was not a result of actions taken by the applicants and as a result of the transitional setback requirement, since the site was developed in 1973 and the existing structure abuts the transitional setback, so no addition could be made to the front of the structure without encroachment into that transitional setback area. The proposed deck won't encroach into the existing or proposed right-of-way and will be located 30 feet further than the existing required setback. Granting the variance will not adversely affect adjacent or contiguous properties because the proposed deck will be located 90 feet from the center line of West Sugar Creek Road. The single-family property located to the south has a street side yard along West Sugar Creek Road. And when you measure that proposed right-of-way and the 15-foot street side yard, their structure is allowed to be a 65-foot distance to the center line as opposed to this requested 90-foot. So that structure can be 25 feet closer to the street center line than what would be allowed with the requested variance. The variance will not impact public safety. And also, we have word from Charlotte Department of Transportation that they do not oppose the request, and the widest right-of-way that would be required is around 50 feet, maybe a couple feet over. Exhibit number 8 is photos of the property, and on the left you can see the large rear yard area. And that's the end of my presentation. If you have any questions for me.
Ms. Jordan, if you're speaking, I think you're muted.
Is the deck going to the on the front of the house or the back of the house?
It's going on the front of the structure.
Okay. Okay, that's all I need to know. Thank you.
There is one neighbor who is attending the meeting. I don't know if they intend to speak for or against or just here for information.
Hi, I'm Sion. Is everybody hearing me?
Yes.
Okay, so I just had a few questions. The first question was asked, where exactly is the deck being built? And you said at the front. And is this a commercial property?
I'm going to ask that the neighbor be sworn in.
Oh,
Okay, ma'am. For the record, state your name and your address.
My name is Sion Slowly, 4608 Lynn Lee Circle, Charlotte, North Carolina, 28269.
Okay, ma'am. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
Yes.
Okay.
Do I go
Okay,
ahead?
ma'am. Ask the question. Yes, you go ahead and ask
Okay.
the question.
So is it a commercial property? And, oh, you said yes?
It's institutional, so it's
Okay.
not commercial. It's a use as a daycare.
Okay. So my thing is it going to impede traffic? That's one. Because that area is kind of funny where it's hard, sometimes it's hard to see going in and out. And if it's a business, a few years, will it affect the resale value of the new construction houses in that area? Because I just bought a house across the street.
I will say that the subject of the variance request is only to add a 10-foot deck to the front, and the use of the property has already been decided in 2019 with the approval of the conditional zoning plan.
Okay. Okay. Thank you.
Thank you. Anyone else has any questions from staff? For staff, I'm sorry. If there are no questions, I ask for a motion to approve the not a variance.
I move that we approve the variance. This is Wilson.
I have a move from Mr. Wilson to approve the variance. Do I have a second?
Long seconds.
And I have a second from Ms. Long. A roll call vote. Mr. Wilson,
Wilson, yes.
Mrs. Long,
Long, yes.
Mrs. Dryden,
Yes.
and Mr. Williamson,
Williamson, yes.
and a yes for myself. The variance has been approved. Going over the facts and finding conditions of law. Ask for a motion to approve the facts and finding condition law as written.
Dryden, I make a motion to approve the finding of facts and conditions of law as written.
I have a motion from Mrs. Dryden to approve the findings and facts and conditions of law. Do I have a second?
Williamson, second.
I have a second from Mr. Wilson. Send it to a vote. Mrs. Dryden,
Dryden, yes.
Mr. Wilson,
Williamson, yes.
Mr. Wilson,
Wilson, yes.
Mrs. Long,
Long, yes.
and a yes for myself. The findings and facts and condition law have been approved. I believe that was the last of our recommendation agenda items, correct?
Yes.
Moving on to our regular agenda item. Do you guys want to take a 10-minute break before we proceed?
Yes, thank
Yes.
you. That would be, thank you.
Okay. All right. We'll take a 10-minute break and reconvene. Okay, we have everyone back?
Yes.
Dryden's here.
Raghu's here.
Long's back.
Williamson's here.
Next case.
Excuse, Mr. Chair, if
Go
I
ahead.
may.
Yes, ma'am?
If you could just give me 1 minute before beginning.
Sure.
Thank you, Mr. Chair. Before we move on to the next cases, I believe Lisa McCarter needs to be sworn.
Okay.
And Max, I just sent you an email if you can.
Yep, I'm forwarding it to Mr. Wilson.
And if we could go ahead and swear in Shad too.
Okay. Are there any others that are giving testimony on this case? So just those two?
Yes.
Okay, Lisa and Chad? For the record, state your name.
I, Lisa.
Chad.
What did he say?
I said for the record, state your name. Look at I think it was Lisa and Shad, correct?
Yes.
Okay. Do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
I do.
Okay. Thanks. Are we okay to proceed?
There's a
Mr. Chair.
Yes. Yeah.
Before we move on to the next cases, if Ms. McCarter could actually swear or affirm on the record regarding the previous statements that she made in the first 4 cases, if I think that would suffice rather than having to go back on those cases.
Okay.
Should I?
Should I swear her in? Or, I mean, how are we handling that?
I think that Ms. McCarter could just swear or affirm the statements that she made on the record in cases. And you can say the case name, but that was true.
I can't hear her. Justina? Yeah.
All right. I, Lisa McCarter, swear that the past statements on the cases heard are true and accurate, and those are cases 2021-020, 2021-034, 2021-036, and 2021-042.
We can't hear you, Mr. Sanchez.
Okay, that's good. Thank you.
Okay, Lisa, I guess we're okay to proceed with case 2021-038.
All right. Our next case is a residential lot area setback and rear yard variance request. The applicant is requesting 3 variances in order to subdivide it property into 3 lots and construct single-family detached dwellings. So I'll give you a minute to look over your findings.
While we're doing that, do we have anyone that's speaking in opposition or for this case?
We have one person signed up to speak regarding the case. They are on the line.
Okay. Well, can we go ahead and get them sworn in?
And that is Sayana Caldwell.
Yes,
Ma'am, are you on the line?
I am.
Okay, ma'am. Before we proceed, go ahead and swear you in. So for the record, can you state your name and address?
I prefer to affirm. My name is Sayona Caldwell. My address 12410 Stowe Acres Drive, Charlotte, North Carolina 28262.
Okay, perfect. Ma'am, do you affirm to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
Yes.
Okay, perfect. Okay, and what we have, the board members we have sitting on this case would be Mr. Dryden, Mrs. Long, Mr. Wilson, Mr. Ragu, and myself. Okay, Lisa, you can proceed.
Exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map of the property. The property is zoned R3 single family. Exhibit number 3 is an aerial map of the property. Exhibit number 4 is a close-up aerial map of the property. Exhibit number 5 is background. The property abuts the Mallard Woods subdivision, and Wilton Great Drive stubs into the property and provides access. There's a home on the property constructed in 2007, and the property also abuts the I-485 right-of-way. Exhibit number 6 is the variance request. The applicant wants to subdivide the property and is requesting 3 variances from zoning ordinance requirements. A 2,000 square foot variance from the 10,000 square foot lot area to allow 8,000 square foot lots. A 10-foot variance from the required 30-foot setback to allow 20-foot setbacks. And a 10-foot variance from the required 45-foot rear yard to allow 35-foot rear yards. Granting the variances doesn't grant subdivision approval, and the property would be required to go through the subdivision process in order to subdivide. Staff does not feel the requests meet the criteria in the ordinance for granting a variance for the property. and it could be subdivided in compliance with zoning without the requested variances as shown on the draft subdivision plan. Exhibit number 7 is the variance request. The hardship results from actions taken by the applicant and doesn't result from the ordinance requirements. The draft plan shows the lot being subdivided in compliance with zoning regulations for lot area, setbacks, and rear yards, which demonstrates that the property can be subdivided in compliance with zoning regulations. So if you look at the chart, there's the zoning standard in the first column. Lot area is 10,000 square foot. The variance request is for 8,000 square foot. And then on the draft plan, the lots shown are 10,000, almost 12,000, and then 120,000 square feet. For the setback and rear yard, the setbacks and rear yards shown on the plan are what is required, but the variance request is for 10 foot less than both of those. Granting the variance would alter the essential character of the neighborhood. The lots in Mallard Woods next to the property are zoned R4, and they meet the minimum ordinance standards. Exhibit number 8 is photos. So it goes from the left side of the property to where the existing 2007 home is in the middle. And then on your right is the right side of the property. And that's the end of my presentation. If you have any questions, the applicant is also here if you have questions of him.
Is there a map that shows how that will be subdivided?
Yes, let me go back to that. So this is the proposed subdivision plan. Now, there's not a map showing what is requested in the variance.
Yeah, that's what I was looking for, what was requested.
Are we able to ask questions now?
Yes.
I do request, well, can we request a map showing how it will be subdivided? And if it, what about our current neighborhood? I'm in Mallard Woods too. And so will the houses be comparable to how our houses are set up? And will they, will the homeowner be required to get a survey with a map and stakes to ensure that his property is not on our playground area? Because I think that's where it sits in the back of. Yeah.
Do we have the applicant on the line?
Mahmoud Al-Kawlak available? Yes.
Okay. And go ahead.
I'm sorry, I did not hear the question clearly.
Well, okay,
Excuse me,
so
Mr.
before you,
Chair.
Yeah, she actually has to be sworn in.
We want to make sure he was sworn.
yes, that was my next next matter. Sir, for the record, please state your name and your address.
Mahmoud Al-Kawlak, 1808 Wilton Gate Drive, Charlotte, North Carolina, 28262.
Sir, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
Okay. Now go ahead, sir. You could present your case.
I'm sorry, I did not hear the question that it was asked. I heard only the last part of it of the about the playground, and yes, it will be stakes for each lot, for each corner of the lot, and we will not interfere with the playground. We will actually spoke to a couple of the neighbors about improving that playground, but of course, we will not get into the playground without any of the residential approval.
Okay. What about, will there be a division between your property and the playground?
There'll
Like a fence or something?
if the neighborhood request that to be added, absolutely, that would be no problem.
All right. And so what about the the development of the houses, how are they, will they be comparable to the houses in Mallow Woods 1, or does that make a difference for the zoning committee? I don't.
Are you asking about the style and the look of the houses or the footage of the houses?
The style and look.
Absolutely, it will be standard just like everybody else. But we might change as far as the outside look, maybe changing bricks or something. But it will be standard as everybody else. Vinyl
Okay.
sidings, brick fronts, just like everybody else.
Okay, and what about the lot? Like there isn't anything on here showing exactly how the lots will be positioned and everything. It's just a blank page. So are you going to submit that?
This is my first time actually submitting such thing, and yes, we will submit the exact corners of all 3 lots. It will be staked, yes. The 2 lots, they are already staked. The left side lot, it has a problem because it has a state manhole. It's sitting on the back side of the lot, on lot number 2. And that's the reason why we're asking for variance to move the house to the front of that lot.
Right,
But
but we can't see that. I'm not a architect, so I can't see it. I don't know how to visualize that. So I suggest that we get some type of map, that plan, and also with this being done, now I know we've had issues before with you driving your 18-wheeler inside the neighborhood. Is this definitely going to be something where for the residents, it's not just for truckers or having the 18-wheelers parked back there where it's like a lot?
the only reason the 18-wheeler came inside there just to bring products.
No, it's been there overnight, and we had to call in zoning several times. But my question is it going to be residential, or is this going to be a lot? That's what one thing that some residents had.
Strictly residential, and
Okay.
I will forbid any large size equipment to come in there to to stay overnight. I will forbid that from happening ever again.
Okay, and this is the only access in and out will be through our neighborhood, correct?
Correct. Because my previous access, it was across the highway. It was across 485. I had my own separate driveway. But when the state came and acquired the front portion of the property for the right of way for the highway for 485, then I was squished and cornered into Mallard Creek development, Mallard Wood development, which is Wilton Gate entrance. That was not my interest from the beginning. I was
Okay.
use that entrance.
Okay, and so what has to be done now? Well, I guess the zoning.
Did not get the question.
Can you repeat that question, ma'am?
Well, I guess with these questions that we have, will it go ahead and be approved, or what's the next step?
Well, that's we're at the zoning here. We'll be deliberating and making that decision.
This is Chad Spencer, and here's some of the concerns that we have as staff is that we're not sure this has been vetted enough to even make a determination that a variance, in our opinion, is appropriate. It has not been submitted to our subdivision staff to review. So we're not even sure that what they're proposing would even meet the subdivision ordinance regulations. I know there's some concerns about, there's a note on this plan that we're looking at that's on government exhibit number 6 that just indicates that right away would be dedicated to NCDOT CDOT. What subdivision would require is that that road be built, not just dedicated. So I'm not sure if that would work. Plus the dimension of that right of way, I don't think that's sufficient. But that's something that would be evaluated through the land development review process with the subdivision staff. And then this is outside of the city limits. It's in the city zoning jurisdiction, but it is outside the city limits, which would then require NCDOT to be involved in the review of this proposed subdivision. So there's a lot of unknowns.
Yes.
So that's why we, at this point, aren't supporting this variance, because we don't even know that this would work.
This is Mrs. Dryden. I have a question for the property owner. In your original application drafts, you were well within the required zonings, and then you changed. Why did you change from what you proposed? Your draft subdivision plan that you did in January of last year complied with all the minimum lot areas, but now all of a sudden you're asking for a variance. Why?
We have found a couple of factors after I cleared the lot, and we took all the vegetation, all the green vegetations. We found major manholes for apparently it seems like city water. Big, huge tank, I was told by the city of Charlotte, are sitting right on the back of the lot. If we do it as directed right now, the 25 foot, the 30 footers, and then the house will be very close to the manholes. I tell you, we were surprised to see major tanks, manholes for the state is inside my property. But anyway, it's for it being there, just for safety, we thought to move the houses to the front of the property, which is that will not obstruct anything. If that would make any sense. The reason, like I said, again, we found the manhole for the state on the back of the property. That's why we decided to move the lot to the front, or to get the variance, and instead of getting the 30 footers, to get the 10 footers.
So there are these cisterns or manhole on both lots, 1 and 2, that require this change in lot size?
No, only on the front, the left lot, the one is facing the 485. The highway.
But you're asking for the variance for both lots.
Yes, the second lot we didn't see. I mean, all that it's included into my private property, which is nothing will be built behind the second home. There's an existing home beside the second home that's going to be built, which will not be into each other. There's nothing obstructing that. The reason why we want to move the house to the front on that second lot is the grading of the lot is extremely deep, very deep. I will need to raise the ground about 15 to 17 feet high, and that's major. That's gonna need major landfill, which is a lot of commercial trucks in and out to fill that area. We didn't want to do that. That's why we asked for the variance.
Thank you.
Especially there's nothing going to be built behind us or in front of us.
This is Ms. Long. I don't think we have enough information to approve this. Do we deny it or do we continue it? Seems like there's more questions than answers at this point.
Yes.
Well, right now we're just taking information because we haven't closed the hearing for us to deliberate. That's where we would make that decision, Krista, whether we approve or disapprove. Is after everyone has had their say and we've had all our questions answered, then we would go into deliberations, and that's where we would have the discussion that you're asking about.
Yeah, I can appreciate that. I just don't think that we have the information we need to make a full judgment. I mean, we can ask questions all morning long. It just doesn't.
All right, and I have one last question. Is there a way for I know the host asks about subdivisions. Is there a way to get that approved, or does it have to be a subdivision, or can they just be single residential lots?
Is that question?
Yeah, this is Shad Spencer. That it would be considered a subdivision, but
Yeah.
they would subdivide into single family lots because the zoning would only allow for single family use. So the lots would be developed with single family homes.
Okay, and they'll have their own like required HOA and all that other kind of stuff, or how does that go?
Possibly, yes. Depending on if they have common open space, because there will also be tree save requirements. And depending on how they handle that requirement, it may require a HOA.
Okay. Awesome. All right. And is there a way for us to get information or to get the results of this? I'm a mental health therapist and I have a 10:30 appointment that's online. So is there a way for us to get the results from this?
Yes, I will make sure that you receive a copy of the written decision letter.
Okay. All right. Is there anything else for me? I have to go.
No, ma'am. If you're finished with your testimony, free to leave.
Okay. Thank you.
Thank you.
Yeah, I think we should identify what are the information that's missing, and then we will ask the owner to bring those information for the next meeting, I think, just before denying it.
I think before we do that, if I'm not mistaken, Mr. Chairman, I think we're supposed to close deliberations before we can start.
That's correct. Correct. Okay. If there are no more testimony, okay, we have not concluded the portion of the case that pertains to presentation and evidence. The board shall not proceed to the discussion and decision portion of the case. Interested parties are permitted to address the board. Interested parties are not permitted to address the board during this portion of today's meeting. However, everyone is permitted to remain present and listen quietly to the board's discussion and vote. That being said, we're now closing the session and going into deliberation phase. With that being said, I think as the board discussed, we're missing a lot of information to make a informed decision on this case. I'm open to hear other board members' suggestions.
I do agree with you, Mr. Chair. We are missing a lot of information. I think we should request the owner to bring us that information so that we can make informed decisions.
Hey, this is Marshall Williams. I'm not sure I'm even sitting on this one, but I had a question about the surrounding zoning for the larger subdivision is R4. And the zoning on this lot is R3. And then there's a large vacant lot to the south that is also R3. It's conceivable that this lot could be made part of the existing subdivision. And if that were the case, would this request kind of fall in line with the R4 zoning, I think is my question. And maybe Shaq can answer that.
Open. hearing.
We're in closed deliberation, so I can't speak.
Gotcha. Thank you.
This is Dryden. I agree with Mr. Katha that we need more information. I'm just not sure what kind of information we need to have. It looks like to me that this request for a rezoning was too early. They haven't done all the other things they need to do. And I would like to see a definitive, this is what the lots are going to look like, where the access is, where the roads are for these properties. And I'm still a little concerned about his original request for subdividing the property, and now he's come back with changes in that. Because it can be done. It might be more expensive, but it can be done. So as it stands right now, I would vote to not approve it. Now, if we can be specific about what information we want him to bring back to us or to the zoning board, then I'm open to that suggestion.
Okay. Mrs. Long, your thoughts?
I would agree with Ms. Dryden. I'm inclined to deny it unless we have some additional information, unless the owner will bring us some additional information down. So, you know, do we continue it? But as it stands right now, I'm inclined to deny.
Okay. Mr. Wilson?
Same here. I am inclined to deny it, and I know that we are in deliberations has been closed, and I think Mrs. Dryden made a good point. If I recall from Lisa's presentation, it looks like this has to go through the subdivision process anyway, and I don't even know if we could even approve it if we could now because of that. So, yeah.
Okay. Mr. Raghu?
Yeah, I do agree with all the members, even though we do need more information and we don't know what it takes for the subdivision of this one. So I do agree with everyone.
Okay. And for myself, I agree with the rest of the board. I think we're missing some information, but before we vote, I would like to open up the session so we can ask Chad the question that we want to ask before we actually make a decision on that. So we open back up the session so we can get some of those questions asked. If we can actually, can we even proceed with this with the information that we have? That's just my suggestion. If you guys, what you guys think about, what's your thoughts on that?
The court reporter's having some problems hearing. Could you restate the last couple sentences, please?
Okay, I was saying if we could, I know a lot of the board are looking for some answers, and because we're in closed deliberations, we can't ask the staff the questions that we want to ask. So my suggestion is we open back up the session so we can ask the staff the questions we want to ask before we make so we can make an informed decision, because we're not sure if it's something that we can actually review because it hasn't gone through the process as far as the subdivision process. So I was asking the board, is that something they are open to? We're opening up the session to ask Chad the question that we want to ask, or are we just ready to make a vote?
Well, I'm open. I think we should reopen the meeting. There were some questions that maybe Chad can answer before we make our final deliberation. So I'm open to that.
Okay. So that being said, let's go ahead and reopen the meeting. so we can ask, staff some questions, so we can make a informed decision on this case. Chad, you there?
Yes.
Okay. I think we have some questions for you. Was someone wanted to ask Chad a question?
Hey, this is Marshall Williamson. I had a question for Shad about the R4 zoning, and this may have been in the presentation, but would the requested lots fall within the R4 zoning as opposed to the R3 zoning that currently exists?
The subject property would have to be developed utilizing the R3 zoning development regulations, unless they, proposed a rezoning, but they would have to comply with R3 standards.
Okay.
And Chad, I have a question. Being that this hasn't even gone through that process, as far as the subdivision process, is this something, again, that we can actually approve?
The subdivision approval process is an administrative process, as long as it meets all the development regulations for zoning, and then all the other regulations that are imposed, like I mentioned earlier, like the tree ordinance. And then it'd have to comply with all the street requirements, but it would be approved administratively. And the lots would have to be verified that they meet the lot size. And so at this point, since we don't have a firm plan as to what they're proposing, we cannot justify that there would be a variance needed. And in addition to the fact that the applicant owns the entire property, so I'm not sure what the hardship would be about making those lot lines extend further into what is identified as Lot 3 on Government Exhibit number 6, which would then make those lots comply with the zoning regulations.
Shad, this is Debbie Dryden. Would the subdivision process, would that include road access and how these houses are going to have driveways to them?
The road would, the construction of the road would be part of the approval process.
Okay, thank you.
Are there any more questions for staff before we close deliberations? Here, there's no more questions. Go ahead.
May I close my statement? I add some.
Sure,
Nothing more than what I said before. This is Mahmoud Al-Kawlak, the owner of the property.
Go ahead, sir.
Yes, sir. As far the reason why I know we can build as is, but I was actually looking out for the rest of the neighborhood why I asked for the variance. I mean, for me to be 10 feet or 20 feet to the back, really, like you mentioned earlier, I own the whole property. But the thing is, the first thing that I saw in my, simple eye, is I want the houses that we want to build here to be on the same level of the other houses. I don't want to be, going. See, if I go 25 feet back of the houses beside me, almost the front of the house is going to be on the back side or the backyard of the houses next to them. So they will be exposing all their privacy. That's one reason why we want to bring the houses to the front. The second reason is for one of the lots, lot number 1 on the left side, which is the one is facing 485, we want to move that up. The reason for that, because of the manhole was sitting back there. So when the department, the DOT, when they came and acquired the front of the property, they gave me the access to Wilton Gate. That was not my access. So when that happened, I was cornered there. Now, part of the plan, it will be a road extended on Wilton Gate Drive. It will be extended 70 feet for the houses to service the house, both homes and the existing home. It will be a cul-de-sac, a street plus a cul-de-sac at the end of it. Again, I was not very clear on my pictures and on my paperwork. This is my first time, but if you request from me to give you a new plot with all the corners of all three houses and all the the rest of the homes that are gonna be there, which is only adding two to the existing one, I will provide the new plot. And as I said again, the street will be extended about 90 feet to the front, plus as a roundabout cul-de-sac. That's all I got. It was very important for us, to keep the homes all aligned and looking, the same shape and looking the same design. You know what I mean? That's all I got.
This is Shad Spencer again. I know there's a couple options for the board on this one. If y'all do choose to continue the hearing, I would recommend that it be continued until the applicant submits something to the city for review and at least get some feedback from the various departments on the development regulations before we proceed with this variance, just so we can get more of a holistic view of what might or might not be needed with regards to variances. Because we don't know what impact some of these development regulations would have on this proposed subdivision at this time. So if you do, like I said, if you do consider the continuance, I would recommend that.
Any other questions for staff or the applicant before we go into closed deliberations?
Before we leave, Chad, could you you don't have to restate everything you said, but I want the wording right. We want, if we decide to continue this, because you're asking the applicant to submit plans to the various government agencies. And could you finish that statement for me?
I guess a simple way to say it is the applicant submit development plans to the Charlotte Development Center for review.
Okay. I just want to get it right, so when we put it in the record that we know what we're asking for. That was my confusion. I knew we needed more information, but I didn't know exactly what kind of information we needed. Okay, thank you.
Okay, that being said, we'll close the meeting and go into closed deliberations. At this time, the meeting is closed. If the board, I think we just heard, I'm, my opinion is we ask for continuance on this case based off of what was just, stated. Open to hear the board's recommendation. Mr. Ryder?
I agree with you, Mr. Chairman. I'm sorry.
No, you go ahead.
I agree. I would like to continue the variance request until the applicant submits development plans to the Charlotte, what Chad said, those last phrases, but it's something specific with, I know Ms. Caldwell was asking the same thing. I'd like to see something other than the the little sketch that he made about exactly what we're going to do and what the problems are before we approve this variance.
Mr. Wilson?
Yes, I agree with Mrs. Dryden. I still think that we, as I mentioned earlier, before we reopen deliberations, that I feel like that we need more information to make an approval of this variance. So I'm in agreement with Mrs. Dryden and the rest of my colleagues on the board.
Mrs. Long?
Long agrees with the rest of the board members. A continuance once, and to hear it once the applicant has submitted the documents to the appropriate other committees.
Okay, and Mr. Ragu?
Yeah, I do agree with the rest of my colleagues, especially getting additional information from the rest of the boards and also rezoning and development boards.
Okay. I ask for a motion that we continue this case once the applicant has provided all necessary documents to Mecklenburg, the appropriate agencies for us to continue.
Yeah.
All right, this is Dryden. I make a motion that we continue this variance request until the applicant has submitted the development plans to the specific Charlotte departments for their approval, and that we get specifics about the size of the lot, the size of the buildings on the lot. That's my request.
I have a motion from Ms. Dryden. Do I have a second?
I second that. Ragu seconds that.
And a second from Ragu. Roll call vote. Ms. Dryden?
Dryden, yes.
Mr. Ragu?
Ragu, yes.
Mr. Wilson?
Wilson, yes.
Mrs. Long?
Long, yes.
And a yes for myself. So the motion to continue this case once the applicant has submitted all necessary documents to the city. That means going through the findings and facts, conditions of law. I think there's some changes that may need to be made.
Since the case has been continued, we don't have to evaluate the finding of facts.
Perfect. Okay, this case has been continued. Next case, 2021-041.
The next case is a residential rear yard variance request. The applicant is requesting an 8-foot variance from the required 40-foot rear yard for an existing addition to the principal structure. And I'll give you a minute to look over your findings if you'll just let me know when you're done.
And Mr. Chairman, before we proceed, I have to hop off at 11, so I probably will not be able to sit on this case. So
Okay.
Max, I hope that doesn't mess with quorum. I don't think it should, but I just wanted to make sure before I jumped off.
Mr. Wilson, are you able to sit on this case?
Yes.
Okay, perfect. Thanks, Mr. Wilson.
Thank you. You're welcome.
Lisa, you can continue.
Okay, exhibit number 1 is the vicinity map of the property. Exhibit number 2 is the zoning map of the property. The property is zoned R4 single family. Exhibit number 3 is an aerial map of the property. And exhibit number 4 is a close-up aerial map of the property. Exhibit number 5 is background. The original home on the property was constructed in 1954 and was compliant with the 40-foot rear yard. In April 2019, a building permit was issued for a rear yard addition with 8 foot in depth. The established rear yard of the original home was about 49.5 feet. A note on the issued permit specified that the plot plan appeared to be in compliance, and this was due to the proposed depth of the addition of 8 feet. Exhibit number 6 is a variance request. The addition to the rear of the home was constructed and issued a Mecklenburg County Certificate of Compliance in July of 2019. The applicant is now selling the home, and a survey commissioned for the sale shows that although the addition was permitted with an 8-foot depth, it was constructed with a depth of 15.9 feet. The addition encroaches 6.4 feet into the 40-foot rear yard. The applicant is requesting an 8-foot variance from the 40-foot rear yard to bring the addition into compliance. Exhibit number 7 is considerations. Staff finds the request does not meet the ordinance criteria for granting a variance. The hardship was a result of actions taken by the applicant because the home addition wasn't constructed according to the plot plan submitted with the building permit. The building permit specified the rear yard was 40 feet, and the plot plan indicated that the addition was 8 feet in depth, but it was constructed with a depth of 15.9 feet, and that caused a 6.4 foot encroachment. Also, prior to the addition, the home was compliant with the 40-foot rear yard. There's no evidence of practical difficulty and unnecessary hardships. The shape and size of the subject property is consistent with other properties within the surrounding community. And the hardship is not peculiar to the applicant's property, and other homes in the area are compliant with the required rear yard. So you can see in the right-hand graphic the rear yards of the other surrounding properties. And actually, the one to the right is an error. It's supposed to be 42 feet. Exhibit number 8 is a photo of the front of the subject property. And that's the end of my presentation. If you have any questions, the applicant is on the meeting and has also prepared a presentation for you.
Before the applicant presents his presentation, can we swear him in? Max, what's the name of the applicant?
Is the applicant on the call?
Yes, the applicant is on the call, and that is Daniel Lineberger.
Mr. Lineberger? Mr. Lineberger, can you hear me?
He is on the call and not muted.
The real estate for the agent is also on the call.
Hey, can you guys hear me?
Yes. It's Mr. Lineberger?
Yes, sir.
Okay, yes. Before you begin, I will have to swear affirm you in. So for the record, state your name and address.
Daniel Lineberger, 2427 Elkwood Circle.
So, Mr. Lineberger, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
You may go ahead with your presentation.
Sure. So all the evidence was shown in my presentation, except for I added the building permit from Carolina Window Roofing and Siding Company. Here, this is the letter for everybody, saying my perspective on the matter. Basically, it says, until this incident occurred, the owner had no knowledge that there were zoning setback issues. It was felt that the GC would re-permit with City of Charlotte correct dimensions, although he did not. I had no knowledge, or the owner had no knowledge or idea on city setbacks, and should not be held liable if issue, as he hired a professional to provide guidance. In the next slide, it shows the permit that was received from the general contractor, stating that it was going to be 13 by 16. But in actuality, the permit written up for the City of Charlotte was 12 by 8, as you guys have seen already. And prior to this, the owner had no knowledge and had really no plot plan for the permit application.
If you just tell me which slide you'd like me to show, and I'll show it.
Can you guys hear me still?
Yes.
It's the plot plan for permit application, Lisa.
Okay.
Yes, this one. So this plot plan was never shown to the owner, and as it was different from the contract that the owner signed with the general contractor. So my evidence would say that I think the general contractor should have re-permitted with the City of Charlotte with the correct dimensions. And this is the first time I've seen this plot plan. And first heard knowledge that there was actual setbacks on the property. The next slide shows the building permit that was received by the owner. The next slide also shows the number of inspections that were done on the property, showing owner did go through the necessary steps that he had to take in order to get an addition done on the house. And then, as you can see on the next slide, the survey that was done by the proposed buyers, showing the setback that the owner, we had no knowledge on until this happened, until this occurred. So basically, we're at a standstill with these buyers. We can't move forward in selling the property until this variance is completed or resolved. That's all I have, y'all. Thank you so much.
Do you have any questions for the
I have a
applicant or
question.
staff?
Lisa, can you go back to that permit application that shows the dimensions of who submitted that? Who is the applicant's signature on there?
I believe that might be the contractor. I'm not exactly certain.
Can Mr. Lineberger confirm that?
Hold on for just a moment. I'm going to look at the piece of paper. Hold on for just a moment. Yeah, so the applicant's signature would be David Hendon, the contractor's name of Carolina Window Company and Roofing.
Thanks.
Do you have any other questions for the applicant or staff? Maxwell, has anyone else signed up to speak on?
There are several people associated with the case on the line, but I do not believe anyone is signed up to speak for or against.
Okay, Mr. Lineberg, before we go into closed deliberations, is there anything else you would like to add?
No, sir.
Okay. Are no more questions? The board will close the meeting and go into deliberation phase. We have now concluded the portion of this case that pertains to the presentation of evidence. The board shall now proceed to discussion and decision portion of the case. Interested parties are not permitted to address the board during this portion of today's meeting. However, anyone is permitted to remain present and listen quietly to the board's discussion and vote. Now declare the meeting closed. All right, board members. Mr. Williamson, what's your start with you? Have any input on the case?
No, just so I'm clear, the building was permitted. It was built not in keeping with the specifications. Did they receive a CO? That's my only question.
Okay. Unfortunately, when we close the deliberation, you can't get that one answered. Ms. Dryden, your thoughts?
Here are my thoughts. The original permit that the contractor submitted was 12 by 8. And then on the plans that the homeowner signed, the property was to be a 13 by something size. But then not only did they add the addition, but they also added a deck, which changed it now to 15 point, the depth is 15.9. So even if he wasn't aware of the first part, he was aware that the deck wasn't compliant because it didn't fit any of the paperwork that he had. And I'm sorry that his window company was not, I mean, it leads me to believe that the window company knew what the requirements were because they put down that it was the original, because of the original size. They knew that they would only get the permit if it was approved at the original, what, 8 by 12. So I am sorry, but I don't know that I can vote to approve this, especially since they added the deck on the back, which extended it from the original 13 to 15. Those are my thoughts. I would love to have some discussion from the board.
Mrs. Long, your thoughts?
Yeah, I feel the way Ms. Dryden does. You know, I respect and appreciate the fact that they had a contractor build this addition. But at some point, it's the owner's responsibility to build what was permitted. And that's a pretty big difference in depth. So right now, I'm inclined to deny it.
Mr. Ragu?
Yeah, I do concur with Ms. Dryden and Ms. Long, especially that the owner should know what's happening. At least he should be looking at the documentation from city. And ultimately, the owner should be the responsible. So I do concur with the rest of my colleagues.
And for myself, I am in agreement with you guys. Again, I think the owner should have been aware of what was being built. And again, as Ms. Ryan said, although you may not understand the first part, but building that deck was definitely not, well, pretty much put it out of regulation as well. So I'm inclined to agree with the rest of the board, and I can't see approving this variance. With that being said, I ask for a motion to approve of the non-variance.
This is Mrs. Dryden. I make a motion to not approve the variance.
I have a motion from Mr. Dryden to not approve the variance. Do I have a second?
I second the motion.
I have a second from Ms. Long. Sent to roll call vote. Ms. Dryden?
Dryden, yes, I vote to not approve.
Okay. Mrs. Long?
Long also approves. I mean, to deny.
Mr. Ragu?
Yes, not to approve.
And Mr. Wilson?
A vote not to approve.
And I also vote not to approve the variance. The variance was not approved. Going over findings and facts and conditions of law. I ask for a motion to approve the findings and facts and conditions of law as written.
Williamson motion to approve the findings of fact and law.
Have a motion to approve the findings and facts of law from Mr. Wilson. Have a second.
I will second that. Raghu will second that.
Second from Mr. Ragu. Roll call vote. Mr. Wilson?
Approved.
Mr. Ragu?
Approved.
Mrs. Dryden?
Dryden, yes.
Mrs. Long?
Long, yes.
And yes from Mr. Welch. The findings and facts, condition law have been approved as written. I think that concludes everything on today's agenda. We have to go back over and approve last month's minutes. Ask for motions to approve last. Go ahead.
Max, where were the minutes? I didn't see minutes. Did you send them to us earlier? And I just
Yeah,
overlooked it?
yes, I sent them last week.
Okay, thank you.
This is Daniel Lineberger. May I say something?
I believe it has been closed. Ms. Sanchez is correct.
I was not aware this addition was, the deck was going to be included in this issue with my addition during this meeting. as the heated square footage per surveyor said that had to be in compliance. They never said anything about the deck. I got the deck done concurrently with the addition.
Hello? Max, are we on?
Yes, I can hear you.
Okay.
I'm unclear of what my next step is.
Can someone staff give him the answer?
Yeah, staff can work with the applicant outside this into compliance.
Thank you. I just wasn't aware that the deck was going to be included in this conversation, not just the square footage.
Thank you, Mr. Lineberger. Board, I'm asking for a motion to approve last month's minutes.
Long makes a motion to approve last month's minutes.
Did I have a second?
Second, Williamson.
I have a motion to approve last month's minutes by Long and a second by Mr. Wilson. Roll call vote, Mrs. Long,
Long, yes.
Mr. Wilson,
Yes.
Mrs. Dryden,
Dryden, yes.
Mr. Ragu,
Raghu, yes.
and a yes from Mr. Welch. Last month's minutes has been approved. Was there anything else on today's agenda that we didn't cover?
Only I have one request of Max. Max, I can't find my copy of the minutes. If you could resend those to me, I'd appreciate it very much.
I will do that.
Thank you. I appreciate it. That's all I had. Thank you, Mr. Welch.
Thank you, Ms. Dryden. Or
Thank
there's
you.
no other pending issue. I now declare the meeting adjourned. Thanks everyone for attending, and again being patient. I will only get better.
Bye, everyone.
Thank you.
Max, you gonna email me those later, correct?
Yes, that's correct. You should have them probably tomorrow.
All right, no problem, Max. Thank you, guys.
Thanks.
Thank you for your patience. Everyone have a good day.